Hello and welcome to Rights and Recourse, a program that tackles constitutional, human rights and legal issues, bringing you information and analysis. My name is Dumile Matez. Remember, you can also be part of our discussion today by calling us on our studio line on 011 714 5497 or 5498 or tweet us at Rights and Recourse. Alternatively, you can email your thoughts to rightsandrecourse@sabc.co.za. In October 2015, Richard Spoor, the lead attorney representing victims of silicosis who worked for the mining industry and who are likely exclusively black, responded to a concern that the legal teams representing these miners were overwhelmingly white. The seniors on that case all ranked among the 20 advocates in the country. As an attorney, Spoor said his interest is winning the case, and there is no latitude to accommodate unsuitable people. That color does not qualify you if you do not meet the other requirements. 2 Fridays ago, members of the Black Lawyers Association marched to the union buildings and protest of the briefing patterns of the state attorney. Today on Rights and Recourse, we examine the briefing patterns largely by the state attorney and the state-owned enterprises. To discuss today's topic, we are joined in the studio by the Honourable Deputy Minister of Justice, Mr. John Jeffrey, Mr. Mvuzo Nojesi, President of the National Association of Democratic Lawyers, Advocate Elizabeth Baloyi-Mere, Advocate from the Advocates for Transformation, and lastly from our Cape Town studio, we're joined by Mr. Walid Brown, Attorney and co-chairperson of the Law Society of South Africa. Ladies and gentlemen, good afternoon and welcome to Rights and Recourse. First of all, that first statement I made, I don't know whether somebody wants to clarify. Probably, let me start with you, Mr. Advocate, because it is the Advocates for Transformation who picked this up at the time and actually ripped the whole statement by Richard Spoor apart.
Yes, thank you. The statement by Richard Spoor, in essence, meant that if you are black, you are incompetent. And so, because his main point is winning the case, he will not involve black advocates, which at this day and age is really sad and regrettable, because that is not the test. He simply neglected the facts before him, and that's why Advocates for Transformation took it up. And as a result, we have come up with several measures. For example, in Johannesburg now, there's a second junior rule, wherein black, mostly female advocates are roped in what we can term high-stake matters, where the litigation is of such great importance that there is both skills transfer and there is economic advancement for mainly PDIs. So it is really factually not true that being black means you are incompetent.
But the biggest gripe among black advocates, Mr. Nojesi and the Minister, I want both of you to answer that question, is the state attorneys and the state-owned enterprises who briefing patterns which are seen to be favoring white legal firms.
Thank you very much. You know, to start this point, if Mr. Talimpof was sitting here, you are asking this question to me, the minister knows what the answer would be. Because this is a matter that we've been discussing even before 1994. What we're saying and what we were emphasizing, particularly from the perspective of Natal, was that there's no way that this country will go forward unless you are undressing the imbalance of the past, where you allow black practitioners to be part of. One of the most sinister situations here, you must be following the JSC interviews, where questions are being asked. This is very funny. The judge that has been kept by the Supreme Court of Appeal for years was Judge Harams. Do you know why? He is the only judge who has what we call intellectual property, who knows intellectual property law. And he was being respected by everybody. Today, the judge who must be respected by everybody in that court is Judge Wallace. Why? Because he knows what we call intellectual property. All the black judges, they cannot be part of that.
I want to come to this issue of the intellectual property law.
Yes.
But first of all, let me get a response from the minister on this issue, the statement I made before. I want to go to Mr. Brown.
Yeah. Look, firstly, just to state that the legal profession, the attorneys and advocates in South Africa do not reflect the race and gender demographics of South Africa. So your worst statistic is if you take the senior advocates or the silks. There are 525 silks in South Africa as at the end of April this year. Only 7 of them are African women. That's less than 1%. So that's a reflection of how bad it is, particularly as you get to the higher levels. But as far as the state attorney and the briefing patterns, the department has had a target of, or has had a category of previously disadvantaged individuals. That would be basically black people and women, or white women. And the target has been in the 70s for the value of briefs. And in the 2015-16 financial year, there was a total of 709 million spent on briefs. 80% of that was given to previously disadvantaged individuals, whereas the target was 77%. In the next financial year, 781 million spent on briefs, 79% of that total given to previously disadvantaged individuals. So I would really, there definitely are problems with the state-owned enterprises in terms of their briefing. Well, they don't use the state attorney. There may be some government departments that don't use the state attorney. Municipalities also don't use the state attorney. But as far as the state attorney work and the briefing patterns, those targets are being met. And in order to ensure transparency, we are now putting the details of the briefs on our website. We're not putting the amount paid, which we'd like to do, because there are questions of our white counsel paid more than black counsel. We're having some resistance, unfortunately, from advocates over putting the value of the briefs, but we feel it should go on. It's public money, and everyone can then see what is being done or not being done.
I want to go down to Cape Town. Mr. Brown, you represent, you're standing on 2 legs. I was telling the team here. You also represent the Black Lawyers Association, and I'm not sure whether they briefed you on this issue. First of all, I want to know what was the response from the Law Society regarding the statements that were made by Mr. Richard Spoor, and also if you want to comment on some of the things we are talking about here.
Yes, look, of course. The issue of transformation and transformation in the legal sector has been something that we've spoken about for years. And the first thing I have to say is that the state has been doing what it can do. The question is whether it's doing enough. If one interrogates the statistics given by the Deputy Minister, the first thing you find is that those statistics are only available from March this year. The second thing, if you interrogate those statistics further, you find that certain departments within the state brief black advocates. Other departments only brief white advocates and don't brief female advocates at all. So when one interrogates the statistics, you find a different picture. Now, in regard to the statement of Mr. Spoor, clearly the Law Society condemns it completely. It is exactly as the learned advocate has said. The perception is then when it comes to excellence in the law, black practitioners don't have a place, and that we condemn. There are many top quality black advocates, black attorneys, black female advocates in this country, and they need to be given an opportunity to do the work, the lucrative work. Mr. Nochezi spoke about intellectual property, but it goes to various other fields of the commercial law in particular. We were recently by the launch of a briefing patterns protocol, and the Deputy Chief Justice spoke, and he spoke about labor law. And he says if you look at the specialized field of labor law, you'll find a large amount of black experts in labor law. And he says the reason for this is the trade union movement in the 80s took a concerted decision to brief only black attorneys and only black advocates. And the results speak for itself. So when the government, the state-owned enterprises, and public companies, private companies, when they change their attitude in this regard, then we will see effective transformation of the legal sector.
But isn't it true, Advocate Baloyi Mere, that Richard Spoor has a point? Every instructing attorney, the interest is winning the case.
Well, for attorneys, Jesse will weigh in on that. The interest is winning the case.
Yes.
But let's go back maybe 2-3 steps and say where did this mostly white male senior advocates get their expertise from? They started off as juniors. I mean, we all get the same qualifications. We all go through university, and we all start somewhere. They were given a chance. They failed, or they were given a chance over and over again. Why am I not being treated the same? Given a chance, if I fail, give me a second chance, and so on and so forth, so that I can build expertise. You cannot expect me to just wake up and be an expert. And still on that, I'd like to weigh in on what the Deputy Minister said about the statistics, because that I cannot leave unchallenged. Yes, you are right. You've got 80% on paper. But 80% of what? 80% of briefs that have been given to black people or to previously disadvantaged people. A person, I'll take a junior of 3 or 5 years in Pretoria or in Cape Town. That junior gets briefed on what we call unlawful arrest. And they sign a form. That form forms part of the statistics. That junior will make 10,000 rands, but they form part of that 80% of statistics. And the state attorney will biasly brief a certain pool of black advocates or a certain pool of black advocates who are paired with white male senior counsel. And that's where the bulk of the money goes. So the statistics without real evidence of what is happening on the ground do not take us anywhere.
Can I just respond?
No, sorry, Minister Mamela, I'm so sorry. Listen, I was listening to the Minister. He's reading this document. He has been continuously reading these papers. We told him, please don't do this thing, because you are going to create a wrong impression. The point here is clear. If you read those papers, they will tell you that, look, briefed black advocates, black attorneys, females and what. You know what? They are given an unlawful arrest. That is a case of that must be fired tomorrow. Here we must speak with specifics. Read yourself. Let me make an example. We cannot talk in abstracts here. Read yourself the case about, what was this case in the Gauteng? The case of the Sandal.
Yes.
Go there. Look who were the advocates. What the state did. Go to his department.
Is this the case that involved?
Yeah, what's this? The toll gates. Go look who were the advocates. Look who was defending. It was the minister. It was there. Look who was there. And then ask yourself, and then you are going to be told, no, with these statistics. Go again, ask him. You look in the Constitutional Court of about 4 cases, except even the what you call the last case about the right, what's this? The private, but all the people except for the first time, they brief Advocate Semenya to be represent the minister, everything. They themselves.
The case that involves Judge Basha.
Go and look.
The president having to explain why he
what I like,
informed the cabinet reshuffle.
Yeah, what I like from you, you are not asking us about what we're talking. Maybe we're talking greedy people. We are talking about what you see. This is what South Africa are talking about.
Let's give the minister a chance. I think the minister probably.
I wanted to.
The Deputy Minister.
Thanks. Just to make it clear that what we're talking about is not number of briefs, because obviously your small unlawful arrests.
Minister, my apologies. Yeah. Does this include disciplinary hearings?
It's any briefing, any briefing, any briefing by the state attorney. it's the value of those briefs. And the 80% that I'm talking about is not the number of briefs, it's the value. And it was important to target the value so that you don't then get confused with numbers. If I can continue without Mr. Nochezi.
Minister, we are making a mistake here. Let's talk about the quality. The point here, we are talking about numbers. You can have 20 briefs to everybody. Why are you not telling him that we as this government, we have given the commercial people who must represent that particular case that deal with the matter of the outer. This is what we did in the government. And number two, why are you not telling him when the case was about the al-Bashir, we did that about this case. We're just talking generalization.
Yes, what I'm talking about...
With respect, Mr. Nochezi, in the al-Bashir case,
they fired all the black lawyers there. They took all the white lawyers to take over.
Give us an opportunity. Yes. The advocate who represented government was Advocate
Mukari in the court. But when we are going there, it was taken over by Councillors.
Let's go back down to Cape Town. Mr. Brown,
yes.
You represent, I said earlier, you represent both the LSSA and the and Black Lawyers Association, unless you say no. But what I was saying earlier, apparently what the BLA was doing 2 Fridays ago, that was not different by protesting at the union buildings. Actually not different from touting. And are there no ethics around it?
No, it's certainly not touting. Look, what the BLA did 2 weeks ago was a momentous occasion. And what it does is it signifies the level of frustration amongst black attorneys. When black attorneys are prepared to give up their office time, don their robes, and march down to court to say that enough is enough. It is time that black attorneys and black firms be given the due respect, in particular by government departments, state-owned companies, etc. It is not touting, of course. It is showing a level of frustration within the black legal profession. To touch again onto what the minister is saying, there are certain departments within the state that do brief black advocates, black female advocates. But there are a number of departments that don't give briefs to any black advocates or female advocates across the board. You'll find that whatever briefs the particular department gives in a particular year goes to white senior counsel or white junior counsel. Now, this is unacceptable. And then when it comes to state-owned enterprises, you will find that the entire or majority of law firms on the panels are majority black. But when it comes to giving the lucrative work out, you'll find they'll go outside of the panel, or they will concentrate on a few firms on the panel, and the large amount of firms on the panel receive no work. And this has to change. And this has got to do with implementing the policies within the state, and also effective monitoring of who gets briefs, the value of the briefs, which advocates get briefs, which law firms get briefs, and how much they get paid. There is no monitoring going on at the moment, and that's the problem.
Madame Baloyi, Mayor, listening to Mr. Nochezi and Mr. Brown, it would seem to me that black advocates and attorneys are looking for high-profile cases from government.
Not necessarily. Black advocates and black attorneys are saying, give us quality work. And there's a reason why. There's always been an outcry that we need the bench, the judges. Let me say the bench, that's the correct word to use, the bench to transform. How do you transform the bench if you do not have quality candidates from the ranks of attorneys and advocates to elevate to the bench? And where does quality come from? Quality comes from doing those complicated cases that are reserved for a particular pool of people. So that if a black attorney or a black advocate is not exposed to intellectual property matters at practice level, how then do you expect them to sit and judge a case on intellectual property matters? So we are not saying give us lucrative briefs. We are not saying give us money on a platter. We are saying let's level the play field. Give me a chance to do this work. to be briefed by Nochesi and do this intellectual property case so that I develop. And maybe I might later be called an expert in that field, and I may end up at the bench, in the bench, and giving judgments in that field.
Is this issue of, I know there was also an issue of, besides intellectual property, there was also the issue of the transfer of properties and to,
Yes,
what is called? The conveyancing.
No, but there was a question here that was left unanswered, where you ask us.
I'm happy you are wide awake.
Yeah, you say, we are asking to all of us, and this is what the South African must understand. You say, lawyers want to win. They brief people to win. I'm asking myself, sitting back, taking myself in 1963 and then 1961, when Mr. Mandela was going to face the revolutionary trial, where every lawyer could not. The black lawyers sit down and put their own people. You see, and then I'm asking myself, and think about the Eastern Cape, where I come from, where Mr. Sangoni, he was the only lawyer in the then Transkei, where there were a lot of lawyers. Everybody were going to go to death sentence. They were incompetent by then. But these were the people who were briefed to save those people not to go to death sentence. And then if you are saying to me, no, lawyers just simply because want winning cases, forget about that. Because today, after those years, now they are so incompetent. I'm so sorry. And then lastly, as the minister is going to answer this question, there are particular points I'm listening with interest here. This thing is not about black people saying we want lucrative work. That's why I differ with some people. I'm going to give you an example now. The minister is here, and ask everybody. I'm coming from Tata. There is an attorney. He represents the department. That's why, Mr. Brown, I disagree with him. There's an attorney. He represents the Department of Home Affairs. He's from Pretoria. He is going to drive a car from Pretoria to the airport. He's going to park his car and then take a flight to Mthatha. Once he gets there, the case is going to be said, no, this case is postponed. And then he goes back. And then that's why the money, how much from Pretoria, and then the government is still out, that's where for money. I mean, there's a senseless way of expenditure here. But that attorney, he is the only one who's allowed to represent the Department of Home Affairs.
Let's get the minister to respond.
Before you respond, in the Eastern Cape, I'm listening to Minister Mtswaleti. He's complaining everywhere. Read every papers. He's saying, no, the health department, lawyers are making all. Even the Chief Justice.
That's a medical legal aspect.
Yes. Mamela, listen here. This is the point. In the Eastern Cape, no, they said that there are only 2 lawyers who can be better serving this purpose. The government is saying, no. That lawyer, that black lawyer of Lusigisigi, that black lawyer of Soshabungove, is not competent to do this thing. Why are we continuing with this debate when our own government does not commit itself? I'm a little bit very angry about
Let's give the
Can I, if I can respond, if Mr. Nochesi can give me the space for it. I think just one thing to emphasize. I mean, Mr. Nochesi earlier was speaking about anecdotal cases. I think it is important when one looks at the whole picture that it is the value of briefs from the State Attorney. And what we've then also done, as Mr. Brown had said, is you can find details of those briefs, unfortunately not including the fees paid, but we'd like to put that on. Hopefully the advocate will support us on that. But you'd see for each State Attorney, you go to the Justice website, you'll see under legislation, you'll see a section on statistics on briefs. Yes, it's only the last 3 months, I think, from March, but it took some pushing to get that put on the website, and it will be put on now every month. But for each State Attorney, there is the detail of the briefs that they give out. So that is there. if there are problems with that, if there are allegations being made that no, it's only a certain pool of black advocates who are briefed, then show us where that is, who's being briefed. Because it's done by the state attorney, as I said. The problem where I would agree with Mr. Brown is that the state-owned enterprises are not using the state attorney. And we need to tighten up there. I think from the Law Society's own investigation, they found that state-owned enterprises were briefing younger counsel, but most of the money was going to senior white counsel. So that's something that needs to be tightened up on. With attorneys, the state government at a provincial and national level primarily uses the state attorney and don't use private attorneys unless it's for correspondence work. We need to tighten up again on state-owned enterprises because they use private attorneys. We also need to tighten up on municipalities because they don't use the state attorney. So there is a lot still to be done, but as far as the briefing pattern specifically from the state attorney, I would argue that the evidence is there that it is going to previously disadvantaged individuals. Yes, we can improve in a lot of cases, but then let's look at the information that's been provided. If Mr. Brown says that there are certain departments that are only using white counsel, well, then tell us which departments, because it's not reflected on the statistics that we're getting.
Well, we've got one now, the Department of Home Affairs.
We'll follow on that. Let me stop on this point. I'm so sorry to interject. You know the BLA march, I mean, when we talk about SOEs, that is I'm going to use the popular word in this country, captured. We know we cannot, as black people, to represent captured institutions. One of the reasons why the BLA march, there was this thing of locomotives, you know. The
locomotives are brought from Spain.
I'm so unfortunate, Mr. Brown, we will take it further. We are not going to discuss individual matters. Unfortunate that it was awarded to Vexman's attorneys. I'm sorry, Mr. Brown is a director there, and then that's why that's why now the PLA come in. The reality we know. The reality is clear, Mr. Matters. The reality is clear, is that when you are going to have more involved matters, black people are just not featured there. We know. Even if you go to SSA, that is a fact.
Just hold it for a while. I'm going to come back to that issue of Workman's organization. If you'd like to join us in today's discussion, you can call us on 011 714 5497 or 5498, or tweet us at Rights and Recourse. Alternatively, you can email your thoughts to rightsandrecourse@sabc.co.za. Stay with us.
Do you have a funeral policy?
Making someone's dreams come true is not always as simple as saying yes. But Avbob's Cashback Funeral Plan not only provides funeral insurance for your family, but also helps you to say yes to life's little extras. Because for every 5 claim-free years, you'll get an entire year's premiums based on your monthly premium value, paid back in cash. SMS Duduza to 41790 and we'll call you. Avbob, we're here for you.
If you want Avbob to contact you, SMS Duduza and your name to 41790.
Welcome back to Rights and Recourse as we discuss the briefing patterns of government and state-owned enterprises here on Rights and Recourse. Mr. Brown, let me come back to you. The question I wanted to ask, probably you can answer this better if one listens to what Mr. Nchesi is saying. You can comment on other things that were raised here, but I wanted to answer this question too. The black economic empowerment in the legal profession has had adverse results in other words, unintended consequences for black advocates or professionals joining up with white companies, only for the white companies to get government business, and the black lawyers or advocates don't get credit for that.
Look, it's difficult to comment on that without talking specifics. What I do know is that you have to give credit to the state-owned companies in a specific regard, is that when they do brief their panel of attorneys, they often insist that the advocate or the service providers that you use are black and female. Whether this is implemented across the board, I can't tell you. And this touches on something that the minister said. He says that the certain tightening up needs to happen within these departments. And I think it goes a bit further than that. The state needs to conduct its own internal investigation in terms of the various departments, ministries, and state-owned companies to find out over a period of 1 year what briefs have gone out, whether those briefs have gone to black advocates, black female attorneys, and the value of those briefs. Then they will understand what the frustration is within the legal sector. And then just lastly, to touch on the issue of the BLA march a few weeks ago. Yes, the tender was awarded by Transnet to Worksman's attorneys. Now, Worksman's attorneys doesn't appoint itself in a matter. But the point that the BLA was making was not the appointment of Worksman's attorneys. The point is the process of appointing any law firm, particularly when it comes to the very large matters. If the state-owned companies have particular policies of having open and transparent processes, they must make that available. They must answer the question, did they consider black-owned law firms for that particular work? Did they consider partnering with black-owned law firms, for example, if they feel that they didn't have sufficient capacity to partner firms with a larger firm to do this work? Or if there isn't capacity to break up the work? These are questions that black-owned law firms are asking themselves, because it's always the high-profile matters that you find that you don't find black attorneys being appointed or black advocates being appointed, whether it is constitutional court matters, SA matters, matters that make the news coverage. And that's where the large amount of frustration comes in. Not that the government is not doing something towards transformation, but the matters that do hit the media tend to have a different demographic to it.
There's something else, Advocate Baloyi. I just want to ask Advocate Baloyi. There's something else around briefing patterns. I have seen over the last couple of years, especially over the last 2 with the high-profile cases, Advocate Vincent Malika, SC, Advocate Simenya, SC, yes. And all of these people, and Advocate Mkari we spoke about earlier, and all of these people have been utilized by the state. And there's something that concerns me, though. There is this reference to the big three. The big three being Wim Trengove, Jeremy Gauntlet, and David Unterhalter. Yeah. Is that a case?
It seems to be the case. And it seems to be that government clearly prefers the big three. We have seen that. We see it with high-profile cases.
But we had Advocate Linda Thomas Ngosi in the other case.
And you only saw her once. You didn't see her again in the next cases. They went back to the big three. That's the unfortunate situation. And tied to that, there's another practice that is happening that maybe members of the public are not aware of. That we are brought into these briefs as juniors. We are briefed as juniors, but the big question is, are we being exposed to briefs, or are we just being there for color coding? For example, because a white male SC has been briefed to stand up in the Constitutional Court, there's a black female sitting in the chair behind or next to the white SC. Was this black junior exposed to real work, or is he or she just there for color coding? But also, I'd like to weigh in on the black empowerment issue, and our colleague from Cape Town mentioned a question of capacity, and it comes back to what I said earlier: leveling the playing fields. How do you expect a small black law firm to have capacity? Let's be realistic. You can't hire a host of people, your legal PAs, your PAs and put them in your law firm. Where are you going to get money to pay them? Because you don't get those high stakes briefs. And when it comes to adjudicating who gets those briefs, it will go to big law firms because they've got capacity. Yet we don't take pains to capacitate the small law firms. And also, 2017, we have BLA having to match on skewed briefing patterns. That should say something to the Ministry of Justice and to you, Deputy Minister. Do we really need BLA to go and march to raise this, to raise awareness around this? What is government doing? What is our government doing to our people? Because transformation is a constitutional imperative. You go to the preamble of the Constitution, you'll find transformation. You'll find it recognizes the injustices of the past. What does it seek to do to redress those?
Let's give the Minister a chance. Minister, before you answer to that, let's take this call from Tabiso in the Free State. Tabiso, good afternoon and welcome to Rights and Recourse. Hello, Tabiso, are you still there?
Yes, I'm still here, Dumile. Good afternoon, and the panel. Actually, Dumile, I would like to congratulate advocates for transformation for taking these steps. You know, our government is really failing us as black people in this country. I just want to make just an example of, look at our president when he's taking lawyers. He's only appointing white lawyers.
Yes.
You know, so it means I'm just trying to make just an example of showing that, you know, things, black lawyers, their value is, you know, it's not taken serious in this country. So they are right to stand for their right and fight for what they believe in. Thank you.
Thank you very much, Savi. So, Minister, I think you can answer that question. Another one is, probably we should ask, do all government law briefings come from the State Attorney's Office? Another question I wanted to ask was, the State Attorney Act is Act number 56 of 1957. It has relics of the old colonial administration, and it has only been amended over the last couple of years. Shouldn't we withdraw that act and start a new thing altogether?
Well, yeah, there's two issues there. Just firstly, on the question of who uses the state attorney. It is meant to be all government departments at a provincial and national level. We are mindful of Mr. Brown's point and are investigating which government departments do not use the state attorney and which attorneys do state-owned entities use. And so we are asking for that.
Because
we'll be asking
my
for that
apologies, Minister, I didn't want to interrupt you. I just wanted to bring this point in. I picked up in the old 1957 Act, the State Attorneys Act, that even in 1957, the Act in 1957 allowed for the state attorney to appoint, to brief lawyers for state-owned enterprises, because they talk about the South African railways and harbours that were also appointed by the state attorney.
The difficulty or the problem currently is that I think state-owned entities are going to their own attorneys. So we don't have those statistics, but we will be getting that information because that is an area that needs to be tightened up. I would, though, say that the BLA has not been fair in its march in terms of saying that government continues to give rewarding and lucrative legal work to white law firms and white male advocates. That's not borne out by the statistics from the state attorney. Definitely, though, also, but I would also agree with the advocate that you can't just take a person and put them in the constitutional court to argue a case. Any person. They've got to actually start by being a junior to a senior in a constitutional court case. So how black juniors are treated by white seniors, or how women are treated by white seniors, is something that needs also to be looked at. Unfortunately, that is more for the Bar Council the advocates profession themselves to look at. And then as far as your question on the state attorney, yes, there are problems with the state attorney. At the moment, there are just decentralized offices in places where the High Court is. There was an amendment passed to appoint a head of the state attorney, the Solicitor General. It ran into some problems in terms of targeting the level at which that person should be paid, because effectively they would be running the largest law firm in the country. We have, though, the Minister has appointed the CEO of Legal Aid South Africa to conduct an investigation and make proposals on the restructuring of the State Attorney's Office to make it more effective. So those are steps that are being taken.
That's another area probably we must revisit in future, the Legal Aid Board, because there too you find that many people are saying the lawyers are ill-equipped to deal with simple issues like criminal issues. I want to come back to you, Mr. Nuchesi. The issues I want to raise, you wanted to respond to what the ministers say.
With some of these matters, I'm a little bit concerned.
Can you speak a bit louder, Mr. Nuchesi?
Okay. There are certain terminology we must correctly not use. I think Ms. Brown is a slipper to say we are frustrated. We are not frustrated. Firstly, we are
beyond frustration.
We are not frustrated. We cannot, because this government has been brought here by us. And then there's a question that you are talking about the three scenarios. No.
The big three.
Advocates, the big three. No, we are so proud about our people. Like you talk, Mr. Ngugai Toby, you talk about Smenya, you talk about Dalimpof, we have been Smaleka, you talk about a lot to talk about, you talk about these people. We are so proud. That's why we as black people, we are not asking for anything. And then this matter reminds me of what the current judge of the Constitutional Court, Mr. Justice Madlanga, told me. He said to me, you see, leave these people to their own thing. All what we can do, we must be on this side so that we can learn more. If the government, and particularly he's saying, he's saying some of the SO, all what I know, I can tell you, I can confirm without hesitation, all the SOEs hate black lawyers. And that's the only conclusion we have. And the government, particularly the minister is here today, he must go and ask them why they hate black lawyers. If we can know that, yes.
You raised...
Can I just respond on that point?
I'll give it up, Mr. Minister.
The Law Society of South Africa set up a team to look at the problem of briefing patterns. And that was headed by...
I was actually part of that team.
Mr. Nochesi is part of that team.
And no one agrees with us.
And that team that came out with a report saying state-owned enterprises to give their work mainly to black male junior advocates and specific white male senior advocates. In terms of payment, specific white senior male advocates are the most paid. So I don't think if the finding of your team was that work was mainly given to black male juniors, then I don't think you can say that they hate black people.
Minister,
but I think the issue is the issue is definitely more work needs to be done with the state-owned enterprises. I would agree fully that there's a gap there, and more work needs to be done as to who they instruct.
I know, Advocate. Sorry, Minister. Minister, you can finish what you're saying.
No, I was going to say as to who they instruct as attorneys and who gets briefed as advocates. But can I also raise, it's also the private sector. I mean, the focus of this discussion for the last 45 minutes has been on the state, on the government.
Well, I think that's what the advocates were marching against. They were marching against government.
They were marching against government, but I think that the state can't be expected to produce all the briefs. And who is the private sector briefing? And there was a protocol that came out from the Law Society. Personally, I think that the protocol is a bit lacking. It needs to be setting targets for law firms in terms of because also the problem you find is you will find black attorneys at a junior level in these bigger law firms, but as you rise up in the ranks, you don't find them. So I think those are areas that need to be looked at as well.
There are two areas. I'm coming to the procurement protocols that were discussed in that action group. Advocate Baloyi, this issue of you raise around the intellectual property law, isn't that an issue of the curriculum or what people choose to read when they go and study law?
I raised the issue, firstly I raised the issue of intellectual property law as an example, but yes, it is not a curriculum issue per se. It is an issue that manifests itself when you get into practice, because there are certain law firms that deal with intellectual property, and you don't find black law firms. I doubt if there's a black law firm that deals with intellectual property.
We all run to Adams and Adams.
Yes, so then it means white law firms will automatically brief white advocates. So you'll have that streaming of growth from white law firms to white advocates. So, and even, let's say, competition law, you will find that there's not a lot of black law firms that do competition law. So obviously the growth in competition law and the expertise will go to white, especially white males. And I'll go and use SARS as an example. SARS uses one white law firm in Pretoria who biasly brief certain white male silks. And I want to challenge the Deputy Minister and say Section 217 of the Constitution is clear. And SOEs fall under state entities. So you have control. We cannot be sitting here and saying government cannot do anything. And government is the largest consumer of legal services. We can talk about private sector, but it's a small percentage. The largest consumer of legal services in South Africa is government, through the state attorney, through SOEs. And Section 217 and the preferential procurement, gives you the instruments to enforce these briefing patterns. But if you're not doing anything, we'll come sit here again 10 years down the line and have the same debate. I
just want to go down to Cape Town, Mr. Njesi. Mr. Brown, probably you can lead us into the procurement protocols that have been adopted by the LSSA, and I went through them a little bit cumbersome. If you can help us there.
Yes, look, it started by the forming of an action group a few years ago and conducting in-depth studies in regard to the complaints we've been receiving from attorneys and advocates on briefing patterns. And the result of a lot of hard work was the signing of the briefing patterns protocol a few weeks ago by various government departments, state-owned companies, law firms, even private sector companies as well. And the commitment in terms of this protocol is that going forward, all of these entities that sign the protocol commit to briefing black law firms, black advocates, and female advocates across the board. This is not the end of the process. It's only the beginning. Now the implementation, monitoring thereof comes into effect. Now, in my view, and as has been touched on, the transformation of the legal sector has three components. The one component we are touching on now, and that's putting pressure on government, marching against government, and ensuring that government complies with its own internal requirements. Now, in this regard, both the BLA and the LSSA have in the past requested information from a number of government departments and state-owned companies. And sometimes they just refuse to give that information. They need to be more transparent about this information. The more transparent they are, the less there is an opportunity for people to criticize them. The second leg of the component is, as the Deputy Minister has touched on, the private sector. There must be pressure put on the private sector as well. The private sector probably has larger commercial briefs, larger value of briefs to give to advocates and to attorney. And we need to put pressure, marches against the private sector as well, requests for information against them as well. And then the third component is the reciprocal obligation that a black attorney and a black advocate has in this profession. You need to make sure that you are sufficiently skilled, that you have excellence in a particular legal field of expertise. So when that call comes, you can deliver a quality service to the client, whether it's the private sector or the public sector.
That's the important thing. The line I pick up from Mr. Brown, you need to make sure that you are sufficiently skilled. And I'd also take you back to something that I read, written by Advocate Khomotso Moroka, who said, she wrote these chilling words. I was shocked. On transformation, I quote, "Transformation of the judiciary without the transformation of the organized advocates profession is quite simply a pipe dream." Are we that far down the line?
That one is correct. That is perfect. Because the basis of the transformed judiciary is the transformed legal profession. That's perfect. But there's something here that you asked and we keep on avoiding to answer. The fronting. With the fronting within the lawyers, where, what's this, I'm using politician terms, rent a black to get money. That's a fact, where some lawyers will go and buy a lot of black lawyers and then make them to be their partners, and they get all the work. This is how you are going to be told that, no, we give this work to that particular person. And then when you look 2 months after that, that black is fired, because you rent a black to get money. We as Natel, we were clear from inception of these things. We want a transformed distribution of legal services, and we want to ensure this thing. Even when you keep on asking this question, how do you make sure that you do know the intellectual property? That's where the government must come in with us, where we take people, we train. This government is going to go as far as it cannot know what it's doing.
Let's allow. I want to, for the minutes we have, I don't know, whatever you wanted to say, Madame Baloyi, Mary, around these issues that we are discussing today, to wrap up, and the Minister will do the final wrap up.
Thank you. The Advocates for Transformation has taken radical decisions in the past few weeks. People should just watch the space. We have decided that enough is enough. 20 years, 23 years into democracy, and there's no really radical change. We need to start changing. We want to see our bench transformed. We want to see both attorneys and advocates participating meaningfully, and that's where we are heading. We are not going to, I think gone are the days when we have to come cap in hand to government department and request for work. We are professionally trained for this work. We deserve to be briefed. We deserve to get quality work. We deserve to be tested alongside our peers. We are not saying don't brief white people in South Africa. We are saying give us an opportunity, level the playing fields. Test me on my competence, not on the color of my skin or where I come from. Where I come from doesn't matter. I have been disadvantaged, but here I am now. I'm competent. I'm saying I can do it. Try me. Don't sit back and say being black means you are incompetent. That's what the Advocates for Transformation are saying, and that's what we are going to. We intend to do. We have been doing it in some way, and we haven't seen much results. And we, as I say, we have taken decisions.
What should we expect? More marches?
No, not more marches, but more action. Expect that a new aggressive animal might be in the offing in the very near future, which will speak very boldly about the advocates' profession.
Minister, it looks like a lot is coming your side.
Sure. Look, clearly, as I said in the beginning, we agree a lot more needs to be done as far as the transformation of the advocates and the attorneys' profession. What I would appeal for is, though, fairness as far as evaluating the state attorney briefs. but more needs to be done, particularly for the state-owned enterprises and other entities of government that are not using, or of the state that are not using the state attorney and municipalities.
By the way, Minister, the President said the Department of Justice should look at this issue.
Yes.
How far are you?
Well, we're in the process of conducting that investigation. Particularly, we've got, as I said, the stats on the state attorney. It's getting the information on people, state-owned entities and departments not using the state attorney. So more needs to be done, but also it requires also the private sector to come to the party. The protocol from the LSSA team was a good start, but it needs to be more specific in terms of setting targets. So I would hope we can continue to work with Advocates for Transformation, with NADEL, with BLA, and with the LSSA to improve things radically.
Minister John Jeffrey, Deputy Minister of Justice, and Madame Baloy Mere, Advocate for Transformation, Mr. Nujesi, who is the President of NADEL, and Mr. Brown down in Cape Town, thank you very much for what seems to have been a riveting discussion. We should have more of these kind of discussion on this show so that we can look at more other issues. I would like to come back to you to discuss the issue of the LLB degree. It's another issue that's standing out. To end this discussion with a quote from a book by an Indian economist and Nobel laureate for economics Amartya Sen, titled The Idea of Justice. When talking about power and its obligation, he says, and I quote, "If someone has the power to make a change that he or she will reduce injustice in the world, then there is strong social argument for doing just that. This obligation of effective power contrasts with the mutual obligation for cooperation at the basic plane of motivational justification." Close quote. This has been Right and Recourse. The views expressed on this show are not necessarily those of the SABC or the Right and Recourse. This program is repeated at 5 on Monday morning. From all of us in the studio, thank you to our guests and goodbye.